3, 2, 1, start. Moderna is expecting to launch a single-dose COVID-19 vaccine in India next year and is in talks with Cipla among other Indian firms, while another US giant Pfizer is ready to offer 5 crore shots in 2021 itself, but it wants significant regulatory relaxations, including indemnification, sources said on Tuesday. While Moderna has conveyed to Indian authorities that it does not have surplus vaccines to share in 2021, there are limited prospects of Johnson & Johnson exporting its jabs from the US to other countries in the near future, the sources privy to discussions added para. 2 rounds of high-level meetings chaired by the Cabinet Secretary were held last week on the availability of vaccines in the global as well as domestic markets, as it was felt that there is an urgent need to procure the jabs at a time that country is reeling under an unprecedented second wave of COVID-19 and a widening gap between supply and requirement para. Currently, the country is using 2 made in India jabs, Covishield and Covaxin, to inoculate its billion-plus population and has administered 20 crore doses since launching the world's largest vaccination drive in mid-January. A third vaccine, Russian-made Sputnik V, has been approved by the government and is being used on a smaller scale at present. In the high-level meeting, officials from the Ministry of External Affairs, Niti Aayog, Department of Biotechnology, Law Ministry, and Health Ministry were present. It was discussed that Moderna doesn't have surplus vaccines to share in 2021 and that it plans to launch its single-dose vaccine for the Indian market only in 2022, for which they are in discussion with Cipla and other Indian companies, a source said para. It is learned that Cipla has already evinced interest in procuring 5 crore doses from Moderna for 2022 and has requested confirmation from the central government in respect of stability in regulatory requirements/policy regime. The Health Ministry has also been asked to take an early decision on Cipla's request regarding support required by them for procurement of Moderna vaccines para. In the case of Pfizer, the US pharma giant has indicated availability of 5 crore vaccine doses, 1 crore in July, 1 crore in August, 2 crore in September, and 1 crore in October for supply to India in 2021, and that it will deal only with Government of India and payment for vaccines will have to be made by Government of India to Pfizer India. The central government will make its own arrangement for further channelization of procured vaccines in the domestic market para. According to another source for the supply of vaccines to India, Pfizer has asked for indemnification from the government of India, and a document in this regard has been received from Pfizer Incorporated. Further, Pfizer has also sought certain relaxations in the regulatory regime, including relaxation in the requirement of post-approval bridging trials and dispensing the requirement of testing their vaccines in CDL into brackets Central Drugs Laboratory. It was suggested that a decision on the issue of Pfizer Incorporated may be taken at the earliest. Para. Though it is undoubtedly very late in the day, I am not willing to uphold the objection because I feel that such a course of action would not be even in the interest of the respondents concerned. I, however, do not propose to allow the petitioner to get away with the fact that this objection has been canvassed at a very late stage, and that too when the cases are substantially part heard, and I therefore propose to issue certain directions whereby I propose to save everything that has happened up to the present point of time, and in addition to that, for having raised objection at a very late stage, to my mind, the petitioners, even if they succeed, will have to compensate the respondents through the payment of reasonably heavy costs. Para. It was pointed out to me on behalf of the respondents, particularly on the basis of Section 126 of the Land Reforms Act, that there is very clear mention to name lands not only in this section but in other parts of the Act, and the submission canvassed was that the jurisdiction of the tribunal is therefore not totally excluded in such cases. Among other things, what the learned counsel pointed out to me was that these are not only more than alternative distinctions, and that therefore the tribunal proceeding with the case and deciding it would not really vitiate the legality of the proceeding. As far as this argument goes, what needs to be pointed out is that where under a statute and by notification the jurisdiction is restricted to a particular forum, namely the special deputy commissioner, by necessary implication the jurisdiction would be excluded from other forums. The law is very clear with regard to the implications of orders passed by the authority devoid of jurisdiction and even if the order is 100% correct on merits, a court will still strike it down because the order is nonist in law. That would be the consequence of the tribunal proceeding to pass orders in these cases, because the position that emerges is that there is no dispute about the fact that after the High Court decision striking down Act number 26 of 1979 and the circular of the state government dated 30th 8 1997, that no authority other than the special deputy commissioner can hear and decide these cases. Para. I need to point out that on the basis of several decisions, the respondents' learned counsel submitted that it is still permissible for the tribunal to hear these cases. The most important of the decision relied upon was the case in Munyalappa versus B.M. Krishnamurthy and others, wherein the applicant had approached the tribunal after the rejection of the claim for occupancy rights under the Inams Abolition Act was denied. This High Court took the view that such an application was not competent, but the Supreme Court pointed out that the rejection of the application by the authority under the Inams Abolition Act did not preclude the applicant from moving the tribunal.